My name is Irina Dashevsky. I am the co-chair of Greenspoon Marder's Cannabis Group, and I'm joined by David Mangone, who is the policy director for the U.S. Cannabis Roundtable. What we want to cover here today with all of you is the Attorney General's recent rescheduling order, what it means, what it does, what it doesn't do, things to look out for, and then we're going to maybe talk about some general policy considerations and issues for the industry at large. And our aim is to go for about 20 minutes and then try to answer questions you might have. So if you have questions, please put them in the Q&A and we will do our best to address those later. So with that, I'm going to turn it over to Mr. Mangone to at least tell us generally what is the U.S. Cannabis Roundtable and what is your vantage point on this before we kind of get into the order itself.
Sure. The U.S. Cannabis Roundtable is a trade association in D.C. That engages in federal advocacy and lobbying with Congress and the administration. We have membership that consists of multi-state operators, single license holders, ancillary service providers, really all across the cannabis supply chain. The organization is the result of a merger from the U.S. Cannabis Council and the National Cannabis Roundtable at the beginning of last year. And as a result, we are really the leading trade association for the cannabis industry in DC.
Well said. And you and I have been working on policy at the federal level for probably 4 or 5 years now. So I will say that we are fairly, intimately familiar with how we got here, and have been working on these things for a while. With that, let's talk about the Attorney General's order from April 23rd, I think. Yeah. Okay.
Yeah, absolutely. So, just by way of background, for those of you who may not be familiar, really the rescheduling process commenced under the Biden administration. There was an October 2022 executive order that directed HHS and the DEA to do a thorough review of the classification of cannabis. Fast forward to this administration. In December, President Trump issued an executive order directing the Attorney General, who at the time was then Pam Bondi, to expeditiously complete the rescheduling process. That translated into Acting Attorney General Todd Blanche issuing a final order on April 23rd, doing just that. The order itself bifurcates medical versus non-medical use. We'll get to that in a minute. But just from a practical standpoint, Attorney General Blanche signed the order. About 5 days later, it appeared in the Federal Register. And in conjunction with that order, there were two additional sort of pieces of news that came out around the same time. The second was that AG Blanche was dispensing with hearings that had commenced under the Biden administration and indicating that new hearings would start later this summer. And then the second sort of piece of news was quickly following AG Blanche's order. The Treasury and the IRS indicated that they would be providing updated guidance on 280E relief as it related to the order. So we can stop there before we get into the meat of the order. And Irina, I'll turn it back to you.
No, thank you for that rundown. Really helpful. So at a very high level, I think it's important for everybody to understand that as we sit here today, cannabis, even state legal cannabis, sits on two parts of the Controlled Substances Act schedule. The adult use cannabis, state legal, is still Schedule 1. And what has been rescheduled is medical cannabis, and that is currently Schedule 3. There will be further hearings. So this is unprecedented. And frankly, it's a little weird. And personally, I think it's untenable. I think it's got to be reconciled. I'm hopeful that the hearings that are commencing June 29th will lead to such a reconciliation. So is that fair to say, David? Like that's kind of where we are right now, and nothing like that's ever happened before, right?
Yeah, and just to get a little bit more granular into what was actually rescheduled versus what was not. So there was two categories of products that were rescheduled. The first is drug products containing cannabis that have received FDA approval. So these are your Marinols, your Sativex, Dravindol.
Epidiolex?
Not Epidiolex. Epidiolex was already been reclassified, and it was
Okay.
CBD compound, not a THC compound. So it's focused specifically on THC compounds. So really, from a practical standpoint, what that means today is Sativex and Dronabinol, which were Schedule 2, moved to Schedule 3. Marinol was already a Schedule 3 classification. But this also means that any product that goes through the traditional FDA drug development pathway, goes through phase 1 through 4 clinical trials that has a THC or other cannabis compound will be classified into Schedule 3 alongside those other FDA approved drugs. The other, and I think much more larger and important category of what was rescheduled was cannabis products that are sold subject to a state issued medical license. So right now, of course, we have 40 states across the country that have moved forward with medical cannabis programs. Interestingly, the order didn't provide any parameters on what state programs qualified. There are obviously very strict programs like Georgia that deal with low THC, limited areas for dispensing, very tightly controlled in terms of conditionless. And then there's very open medical programs like Washington, D.C., where you can self-certify as a patient saying that, I have a condition that will be aided or assisted by the use of medical cannabis. So it would have fully been within the purview of the Attorney General to put sort of guardrails on what counted as medical cannabis and what didn't. But they just say we're going to give a lot of deference to states that have set up licensing frameworks around this issue. So I think that is a positive sign. As far as what was not rescheduled, Arena mentioned, adult use cannabis, but it is also any cannabis or cannabis extract that hasn't been incorporated into a FDA approved product or that is sold subject to a state licensed medical product. So this captures some of the intoxicating hemp products. The order does specifically exclude hemp as it's defined under the 2018 Farm Bill, but it does acknowledge the definitional change that's coming to hemp in November. Some of these products are going to be captured under what is not rescheduled. It also does not reschedule any synthetics. There's a specific exclusion to those types of substances. So the universe we're really working with, I think for a lot of people on this call, is those state licensed medical cannabis products. The FDA approved drugs containing cannabis. That's sort of a smaller implication of this executive order and the final order that implements it. The medical, the state licensed medical cannabis products are really the bigger universe of products that we're dealing with right here.
So, kind of drilling down on the implications of that. Many states have dual use licensees, and I just want to walk through kind of the spectrum, and we'll get to taxes, but I really want to kind of talk about the more practical, like if you hold a medical license and you hold a adult use license, what do you think that means for those folks by way of like their functionality and their operations? Because it seems to me like the federal government's acknowledging that these medical products, and state programs can be sort of grandfathered in under a streamlined process, and these folks can actually seek a license from the DEA, which, I'll have you expand on. But how do we know if you're dual use, which aspect of this gets pulled in and which is excluded? And this is most interesting, I think, for dispensaries, because I understand if you're, producing products under a medical license, that's kind of clear. Or if you're in a medical only state, that's kind of clear. But what about for the folks who, I'll give you an example, maybe you could work with it. But here in Illinois, recent changes have led to a situation where a craft grower, which is an adult use license, can now sell its products to a medical dispensary.
Mm-hmm.
The product isn't necessarily, a medical product or under that guise, but it's now being sold to a patient through a medical dispensary. So I'm just curious, how do you think that's going to shake out?
Well, and first of all, I just want to highlight the sort of the registration window that you pointed towards. And so, the portal on the DEA's website for medical dispensaries and the applications went live yesterday around noon. And so there's already been, some companies with medical only, supply chains, medical only states who have already completed the application process. This includes some of or at least one of the larger MSOs, where, I know for certain that they have uh, states they operated in that have both medical and adult use cannabis businesses. How the form
Let
is,
me let me just cut you off and drill down something you said. You know that someone's already completed that. So that suggests that this is not a complicated app, meaning,
yes.
you
Uh,
know, folks who are familiar with the app process, it can be very arduous.
right.
But this is streamlined, which is, I think, is a benefit for folks. Yes.
That's right. And I will say the company that I know that has done it is certainly one of the larger ones. So they are probably
Well equipped.
well equipped to move through these applications. They probably had a good anticipation of what was going to be asked on this application. But that being said, it is not seem to be the same type of uh, arduous process as uh, the application process itself for state licensure. You certainly need to be prepared to talk about security, talk about, diversion control, and the DEA website lists all of the things they are looking for information on. But um, the application itself does seem to be fairly quick. It does seem to be fairly straightforward. There are questions on the application that ask about whether you intend to dispense medical cannabis, and then the following question is whether you intend to also dispense recreational cannabis. So this is a question that is pretty straightforward on the form. Um, I am not providing any of the attendees on this call legal advice at this point, but I discourage very, very strongly anyone lying on a federal form. It carries a penalty of up to $250,000, up to 5 years in prison. You need to be very transparent with your disclosures, even if there is not a clear answer in terms of how the DEA is going to deal with adult use versus medical cannabis. So I encourage, if you are an operator on this call, to talk with your internal counsel, talk with your compliance department. If you're a service provider on this call, I think being ready to, answer that question and tell your clients to fill out the form honestly and truthfully is going to lead, all likelihood, to the best success. Now, the DEA has not yet put forward a registration form for cultivators or manufacturers. It's only dispensing. From the order itself, it's unclear if they intend to do so prior to this hearing in June. They do discuss things that maintain Schedule 1 as bulk marijuana manufacturers. It's unclear whether or not they are considering all manufacturers, whether or not they're creating products that are medical or adult use as falling into that category. But again, this is the second day that this portal has been live. We do expect more guidance to come, at least from on the Treasury side, and I would not be surprised if there is more guidance during the application process from the Department of Justice and the DEA. So if you have questions that you're unsure about the resolution, including the adult use versus medical use distinction, and you are willing to wait a little
Yep.
bit later into the application process, some of those things may reveal themselves.
And the application process is going to be open for 60 days. Did I
That's
get
right.
that right?
So as I mentioned, it opened yesterday around noon. It will be open until June 29th, which is right before the hearing commences.
So, again, we are not providing you all legal advice, but just strategically, being a first mover here doesn't seem to have any advantage. To
Right.
David's point, there may be guidance. So, look, it may be a productive decision to, again, nobody should be waiting for the last minute, but as we've just heard, this is not a cumbersome application. It's something that folks should be able to get through relatively easy. Obviously, give yourself a buffer of time, but it may make sense
Right.
to hang out and see what content comes out, what guidance comes out.
And with the 60-day window, the order indicates that you will be granted expedited processing within 6 months. The order does not say if you don't file within 60 days that you will be permanently shut out from getting a DEA registration. And think from a standpoint of a new state comes online, license structure changed in a state, there's going to be the ability for those new marketplaces to fill out a DEA registration. I'll use North Carolina and South Carolina as an example. If those states decide to move forward with medical programs, they're going to be able to register through this process. That being said, there are a lot of licenses that operate across the markets in the United States. I do think if you are in the position to do so within the next 60 days, and have your legal questions answered by your own compliance teams, that proceeding with this probably does uh, you know prevent a backlog from building up at the DEA where they may not be anticipating to process thousands and thousands of applications.
So time moves quickly. I want to go through two more things with you guys. Um, and again, maybe we'll be able to push this back a few minutes to try to answer more questions. But David, there's a feature in this order that I think is very new, um, which essentially requires a producer to transact with the DEA
Hmm.
for a nominal price. And it seems like, I think if I recall it correctly, it dealt with like bulk product. I don't know that you're transacting in finished product. I'd love to hear your quick thoughts on that. And, so if you are getting this DEA license, that's where this is headed. You'll be able to transact with the DEA and then transact with other DEA licensees.
Hmm. Yeah, and I want to start by saying this is my opinion on this. There hasn't been guidance on this specific issue as it relates to cannabis and cannabis products from the DEA. But there is not, at least in my opinion, going to be the requirement for physical transfer. Um, DEA does not have warehouses. DEA does not have facilities to take every product from the supply chain, hold it as a de facto wholesaler and then sell it back. So we're talking about probably an instantaneous quote unquote transfer of title, where for a brief moment in the transaction, DEA will have title to the product. They'll collect their administrative fee. And then the sale will proceed as it normally does inside a medical dispensary. Um, we have a much smaller example of this with the current Schedule 1 licensees who produce cannabis products for research, where the DEA maintains access, and I put air quotes around that, by basically being able to view records, inventory, anything that is analogous to what's going to be in a track and trace system. It's basically the ability of the governing agency to be aware at all points where a product is in the supply chain, and then have the opportunity, if so needed, for a physical inspection, but there's not going to be a physical transfer of product between licensees and the DEA.
And just to clarify, do you happen to know at what stage this transaction might take place? Is it at a finished good transaction? Is it at like, you
I,
know,
I, I candidly do not know,
okay.
and it's just not something that has played out yet. And I think we are going to have to sort of see this in practice once licensees get their initial approvals from the DEA. I think you likely need not necessarily something that rises to the level of guidance, but probably an internal configuration of DEA processes that are going to be changed as a result of this nominal
Now,
transaction.
everybody, who gets this license, it's not a must get, meaning you don't have to get this DA license to avail yourself of the sort of 280E aspect of this order. So essentially, and I think the Treasury came out with guidance that, for this taxable year, 2026, if you are a medical licensee and your products and rescheduling applies to you, you can avail yourself of not having to pay 280E. So I want to be clear that you don't need this DEA license for that aspect of it. Um, David, do you think that, other than being able to transact with the DEA and then other licensees, do you think that some of the federal policy, which I want to get into, some of the proposed legislation will center around applying to folks who have this DA license. And is that a way that like the federal government can say, look, if you get this license, you're captured in this sphere of stuff that now this legislation can apply to? Or are we cutting it a little thin?
So something the order does reference is the import-export permit, and it's the section that it is discussed in is largely about the FDA-approved products containing cannabis. But my strong suspicion is that if you walk through the process of getting a DEA registration, you will be treated on an equivalent level as other Schedule III manufacturers and distributors of controlled substances. And I say that sort of as a dancing around the issue of if you are strictly compliant with, DEA's Schedule III manufacturing, they're not going to let you import and export without that license. They're not going to let you, uh, maybe afford yourself the benefit of um, trademark protection, perhaps, without that license. And then even on the 280E piece, depending on what the Treasury guidance says, and that's a big part of this. There may be at least an effort by the IRS to say if you don't have a DEA license, we are not going to be willing to look at 280E and how it affects your business. I'm not saying that's going to happen for sure, and it's dependent on the guidance that's going to be issued by the IRS. But I could see that as a potential challenge moving forward if these DEA licenses are not required.
That's interesting. Okay. Um, we've got about 5 minutes left on what I thought was our main time. I want to touch on one more thing with David because he's a federal policy expert. Can you walk us through what, if any, legislation is sort of been proposed in Congress and the interplay here? If you think that this development, this rescheduling, gives folks in Congress an impetus to actually finally pass some legislation on cannabis.
Yeah, and so a really important part of the rule in order is it creates a protection for liability and criminal prosecution for researchers obtaining product from commercial dispensaries. There's probably been about a dozen legislative proposals on Capitol Hill that have really wanted to do just that, be able to have researchers use commercially available products instead of the cannabis that was grown on the farm in University of Mississippi that's managed by the National Institute of Drug Abuse. And so allowing researchers to actually use commercially available products, I think in turn is going to dictate better policy on Capitol Hill. I think you will see less members using research bills as a way to delay progress because we'll be getting real-time, updates and answers. As far as other bills like the Safe Banking Act and the Climb Act, we are still, we're in April, almost May, of the second session of this Congress, and safe banking hasn't been reintroduced. My hope is that with updated Treasury guidance and with this move by the administration, um, that bill gets more momentum. Um, or it might be a reality where that bill becomes less but still needed. But I think you do see um, members, particularly of the Republican Party, respond positively to this move by the president, who have maybe not been willing to be a vocal advocate for cannabis legislation prior to this point. You're going to have your continued prohibitionists in Congress who, no matter what the president says, are going to continue to put forward pieces of legislation and appropriations provisions that try to block progress. But I do think now that the White House is very publicly talking about this move, they're cheering it as a positive development. You will likely see members who may not have weighed in the issue before be willing to either vote for a bill or to even to put their name on one.
Okay. Um, I'm going to try to get to some of these questions, everybody. And if we don't, you have access to our emails. Feel free to email. We'll try to get you more answers. Just to confirm, I heard correctly, the DA registration is only for dispensary licensees, not processor licensees. Is that correct? I believe that is correct. Again, medical, right?
That's right. And now, there may be it may be worthwhile for some of the attendees on this call or the broader industry to use a test case to try to register as a manufacturer, as a cultivator, and see if the portal and the application lets them go through. It's something I can't do practically because one of the first questions it asks is for your state licensed number that corresponds with your registration license. So I can't really even get past the first page to figure that out. So from an operator perspective, if you go through those questions and answer those questions, maybe you can submit as a manufacturer or cultivator, but there is not a unique form for either of those sects of the business.
Okay, couple more. What is the status of the retroactive tax recommendation that the order strongly suggests? So I think I'll try to take that one on. That's just a suggestion, and I think the IRS and the Treasury is going to issue guidance. My layperson's understanding is the order was effective immediately and on a go forward basis. So that's late April 2026 go forward. The Treasury issued a statement basically saying that for the purposes of 280, rescheduling generally will be considered to first apply to a business's full taxable year that includes the effective date of the final order. So in a way, the retroactivity was let's start Jan 1, 2026, rather than April 23rd going forward. So there's some of that, but I think, you know, tax folks are really digesting what else this could mean. David, anything else to add on that?
No, I think that covers it. And again, I think it should be encouraging to see how quickly the Treasury issued a at least press release saying that guidance was coming. Government typically grinds pretty slowly in DC, but having them say we understand that we have guidance that needs to be updated, almost simultaneously with the issuance of the actual order, I think that's really encouraging. I think we'll see the specifics from Treasury in short order.
Okay. Are you willing to stay on a few more minutes? We could try
Yeah,
to plow through these
yeah,
questions. All right,
I'm good.
folks, we're going to try to get through some of these. Um, so there's a lot of questions. I'm going to try to summarize about the dual use and just how to distinguish and what the implications of this are.
Right.
What it would be dependent on, right? Is it dependent on the status of the purchaser? Is it dependent on how the product maybe was tracked in a seed to sale tracking system? Do we have any clarity on that?
So we don't. And for the states that have either collapsed licenses or dual licenses, there is very little clarity, at least at this point, between the final rule and the order, how that process moves forward. The the I think the fact that the DEA registration form asks about those two distinct types of operations, both medical and adult use, shows that the DEA is contemplating that issue, but we don't have any indication from them as how they're going to resolve that issue. As I said earlier, the order could have easily said medical cannabis only counts if it's limited format, if it is a limited qualifying condition, if it, goes directly through a pharmacy, those kind of thing. But none of those parameters were included. So the DEA is going to get applications from very strictly controlled states, and they're going to get applications from states that have had robust adult use marketplaces. But the way the order reads on its face is that they are going to treat those applications, at least on the medical side, as exactly the same. I think once they start receiving applications and probably in all likelihood see the volume of applicants that have indicated that they have either a dual use license or have multiple operations, uh, I would imagine that that is something that they may not publicly address, but I think they'll have to develop an internal policy of how to sort through those applications. I think they open themselves up for serious litigation, including from state governments, if they do blanket denials for anyone that has a dual use license or has adult use operations. And again, you have a number of states that have collapsed their medical markets into one licensing structure. You also have states who can make a strong case that a lot of the consumers who are shopping in adult use dispensaries are still using for medical purposes.
Yes.
And I use Alaska as the example for this all the time. When Alaska moved forward with their adult use initiative, the medical market fell by about 80%, but you saw year over year consistent buying trends. So those individuals who are in the medical market, it's not like they went anywhere. It's not like they stopped buying cannabis. They just were buying cannabis from a differently labeled store. So I do think that between now and June, the clearest answer is if you are in a medical only state with medical operations, that is the clearest cut in terms of what will be getting a DEA registration. I think if you are in a dual use licensed state or have adult use operations within your business portfolio, that is likely going to be answered during the June hearing. Of course, to get that expedited processing, you have to submit an application before the hearing starts, so you won't get that clarity. But Arena, you made this point at the top of the call, like finding a logical way to say part of cannabis should be Schedule 1, well, part should be Schedule 3. It's really challenging to come up with a cohesive argument as to why that would ultimately stand. I certainly understand and appreciate why AG Blanche use the treaty provisions to move forward with medical. And I also understand the limitations of the international treaties when it comes to adult use. But the CSA is structured in a way where it doesn't really make that judgment call of, final use. It just says, does this have medical utility or is there and what is the abuse potential? And abuse potential covers non-medical uses of a drug. That's one of the factors that HHS looks at in determining the abuse potential. So when you make the assessment that cannabis lands on Schedule 3, that's making an assessment that not cannabis that's sold through a medical channel. It's talking about the plant
Cannabis.
itself, the product itself. And so I think when you sort of press down into how do we ultimately make that distinction, this would be the first time and only time that the CSA makes a distinction based on final use.
Yeah. And I don't think that's tenable. I think it's so intellectually inconsistent that hopefully the right thing happens coming out of these hearings and it all just moves to Schedule 3. But we have to see.
Yeah,
Currently, cannabis straddles Schedule 1 and Schedule 3 on the CSA.
that's right.
There's one final question that I really like that I think encompasses a couple of issues. I'm gonna raise it, but again, folks, you are welcome to email us and we can try to get you some answers as best we can. Will the DEA license allow transfer of product across state lines? So, look, I think that's where this is going in some ways, that a DEA licensed, you know, producer will be able to, after they transact with the DEA, will be able to send products to a DA licensed dispensary. The one thing that I've talked to several regulators about that they're looking into and considering is that could be a violation of state law. Most of these state licenses say you can't, take state legal cannabis outside the border. So I think that there's just a lot of work that needs to be done um, on those issues. I would imagine that states would adjust to allow for this. I think that's sort of, I haven't heard anything to the contrary, and wouldn't necessarily be logical for states to continue to have that restriction and limit folks that way. I mean, there's going to be an interplay between federal and state law in that regard. David, any thoughts on that?
Yeah, nothing yet on the interstate commerce piece. Again, I think the FDA approved product that contains a cannabis or cannabis extract, that pathway for interstate commerce is much clearer because that's much more akin to Tylenol with codeine, right? That's that part of Schedule 3.
Right.
The Schedule 3 part of state approved medical cannabis license, I agree that there are states that have written anti-diversion policies into their state law, some even into their state constitutions. So I think you probably run into challenges at the state level with that piece. But again, I think we're going to need a test case on this once applications are approved and registrations are approved. Whether that's getting an advisory opinion or whether that's, trying it in practice and seeing what the outcome is. But it's a question that we can't really answer practically yet. because we don't know exactly what the DEA approval process is. And if you get an approval for one site, does that mean that your approvals are granted for other sites you may have in other states? That's not something that's innately clear from the application or the order itself.
Okay. Well, we went a little over. We appreciate everyone who joined. Again, we're happy to conduct any follow-up questions, answers that you would like. Just get in touch with us via email. So thank you all. Hopefully, this was at least a pretty good primer for things to be looking out for and thinking about. We appreciate everyone's time. Thanks, guys.
Thanks all so much.
David, thank you. Thank you for joining us.
Of course.